the final topic that we wanted to talk about is the possibility of Delaware receivership filing as a means of imposing third-party supervision on an issuer that has been acting inappropriately from a bondholder perspective, and also indirectly as a way of triggering action by the trustee under the no action provision, because again, a appointment of a receiver constitutes a breach under the terms of the indenture or the deed. And in recent years, there's been an increase in receivership filings in Delaware Chancery Court and elsewhere. Delaware Chancery Court, simply because very often the issuer, whether it's an SPV or not, is is organized under the laws of Delaware, and of course Delaware Chancery Court is a sophisticated court that is well suited for these types of cases. And so the Delaware Code, for example, New York Code has similar provisions, but the Delaware Code contains provisions allowing for receivership for purposes of corporate dissolution and where there is deadlock. But it also contains a very broad provision that says a corporate receiver can be appointed where a creditor shows insolvency, that the issuer is insolvent, and that there are exigent circumstances warranting such relief. So again, to go back to the discussion we had earlier about the no action provision, if you posit a situation where your issuer is insolvent and you believe is engaged in fraudulent conveyances, for example, stripping assets out of the baskets of securities that are available to note holders and moving those assets around amongst its subsidiaries to entities that are outside the basket of securities pledged to secure note holders, that may be sufficient, or at least arguably sufficient, as exigent circumstances warranting relief. And insolvency under Delaware law for this purpose is defined as either balance sheet insolvency, meaning that liabilities exceed assets, net of shareholder equity, of course, or equitable insolvency, meaning that the issuer is unable to meet its current obligations as they come due. Unlike bankruptcy, a single creditor or the trustee, if there's if the no action provision can be satisfied, can bring a receivership action, and receivership can be faster, less expensive, and more flexible than an involuntary bankruptcy, in part because a single creditor can bring a receivership action, and it's not necessary to have 3 or more creditors, et cetera, and satisfy the other requirements for a involuntary bankruptcy filing.
Gary, is this one of these cases where sometimes there can be a kind of a potential trap set up by the language of a no action clause if the debtor there hasn't been an event of default?
Yeah, I mean, I think that if you're successful in obtaining the receivership, then now you have an event of default, and you can instruct the trustee. Now, at that point, of course, you've already gotten some supervision of the issuer, so the bondholder may be satisfied with that. Thank you. I see that our time is up, and we have indeed finished our slides, so thank you all for watching.
We appreciate the opportunity to do this.
And please feel free to contact us if you have any questions. Thank you.